I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello, my name is Jessica Henry, and I'll be your host. Today we have the pleasure of talking with Mary Price. Mary Price is the General Counsel of FAMM, formerly known as Families Against Mandatory Minimums. She directs the FAMM Litigation Project and supports reform of sentencing and corrections, law and policy before state legislatures and agencies, and also before the U.S. Sentencing Commission, the Bureau of Prisons, and the U.S. Department of Justice. Mary is a founder of the Compassionate Release Clearinghouse, a joint project of FAMM and the NACDL, the National Association of Criminal Defense Lawyers. The Clearinghouse identifies incarcerated individuals in federal prison who are eligible for compassionate release and recruits, trains, and supports pro bono lawyers to represent them. She has authored several reports about compassionate release, including Everywhere and Nowhere, Compassionate Release in the States, and she maintains a report card project grading states, medical, and geriatric release programs. Mary is a member of the American Law Institute and was honored in 2019 by the NACDL with its Restoration of Rights Award for her work on clemency and compassionate release. Thank you so much, Mary Price, for being on the show.
Thank you so much for having me. I'm just delighted to talk with you about this topic.
Yeah, so we're going to be exploring compassionate release today. It's a subject I suspect a lot of listeners aren't super familiar with, but before we get started on that, I'm wondering if you could just tell us what is FAMM? What do they do, and what do you do for FAMM?
Thank you so much. So FAMM was, as you know, formerly Families Against Mandatory Minimums, and we were founded over 35 years ago by Julie Stewart, whose brother had been convicted of growing marijuana with some friends in a barn and was sentenced in the federal system to 5 years in prison. This was relatively early in the days of mandatory minimums, and the judge had to explain to a courtroom of rather shocked people that what seemed like a long sentence, and we know that there are much longer sentences in the federal system, his hands were tied. He could not do anything else. So she founded this organization as somebody who was a loved one of a person who was incarcerated and began to gather together people who were affected or had been harmed by the criminal justice system, and particularly by sentencing. And the point of the organization is to elevate the voices of individuals who have been affected by the criminal justice system. We call them impacted individuals, and to elevate those voices, not only to tell stories, but in the reform space, to try and convince lawmakers and policymakers about the harms of unjust sentencing. Since our founding, we've expanded our reach a great deal. So we have thousands of members, both inside and outside prison. We work on, of course, sentencing reform, including mandatory minimums, but not exclusively mandatory minimums. We work on corrections reform. And I think what we're going to be talking about a lot more today on second chances. There's lots of people who are incarcerated and have been there for a long time and have years yet to go. And we are trying to open up avenues for systems to be able to reevaluate whether those sentences, whether they fit at all in the first place, continue to fit those individuals today.
Yeah, and I mean, FAMM does such great work. For those of you that aren't familiar with their work, please go to their website. I mean, they do such terrific, cutting-edge stuff. And Mary, one of the reasons I wanted to have you in particular on the show is because of your expertise in compassionate release. And I'm wondering if you could just tell us, what is compassionate release?
We use compassionate release as an umbrella term that covers early release from prison, programs that provide for early release from prison of individuals who are enduring serious medical conditions, facing the end of life, and for elders who have age-related conditions and or have served some minimum amount of time in prison. Those are the most classic forms of what we call compassionate release.
Because, one of the things, just to really set the stage here, is, when people are sentenced to really long terms of prison, to life without parole, they get old in prison. And just because you're in prison doesn't mean you don't get age related illnesses and dementia and all the things that come with aging. So, having a program that at least allows people to be considered for release based on those things is sort of an important idea. Let me ask you a question. Who came up with this term compassionate? I mean, is compassionate release compassionate?
I don't know who came up with it. That's a very good question, as is your second part of it, which is it compassionate? And in fact, I don't think so. It has been a term that's been used principally for the federal system, and I think just began to sort of weave its way into other programs. It's surprising, though, because compassionate release doesn't get used very often as the name of a program. We just use it as an umbrella term, and we have reasons for doing that. It's not compassionate, and very few states have compassion in their title, but we were first introduced to compassionate release by people who reached out to us, our members who were incarcerated, their loved ones on the outside, who were really struggling to learn about compassionate release and how to use it. They were very concerned. They could not get information. And we decided to try and find out that information for them. And we would research and look into the laws and look into regulations, into policies. And we were struck over and over again at the sheer complexity and the sort of hiddenness and the barriers that were built into state programs. I mean, we were lawyers when we did our compassionate release memos. It took us months and months to unpack all these state programs because it was so hard to find this. Imagine somebody who's very ill sitting at a terrible computer, if they even have one in their state system, trying to get this information. Only a handful of programs tell incarcerated people that compassionate release even exists, much less how to apply for it. There are programs that have procedures that result in lengthy delays for people once they've asked for compassionate release. There is only one program that I'm aware of in the entire country that keeps family members apprised of what's going on the outside. So we use the term compassionate release because we think that every single program that we study, from the federal system all the way down to the state systems, would benefit from centering compassion, taking a compassionate-based look at what it means for a prisoner and or their loved ones to go through this process in light of the complexity and the barriers we found. We just want to be sure that individuals are centered in the conversation as we do the reform work about compassionate release.
Why is it so important? I mean, somebody did something and they got sentenced to some kind of lengthy term imprisonment. Why should they get compassion? Why should they get an opportunity to be released?
I think there's a lot of reasons. One of them is, as an organization, FAMM focuses a fair amount on providing avenues for second chances to incarcerated people. And we think about it as those individuals for whom continued imprisonment no longer serves the purposes of sentencing. So when we as a system send somebody away, we want to punish them, we want to rehabilitate them, we want to deter others from crime. We have a variety of reasons or purposes of punishment. But at some point, whether it's because a person is severely ill or debilitated or incapacitated by a medical or a cognitive condition, or people who are facing the end of their lives or aging in prison, it no longer makes sense for them to be there. It no longer serves the individual, nor does it serve society's interests. It's a very costly process to keep people incarcerated. And these are the individuals. I mean, we think of second chances for lots more kinds of categories of people, but these people, the sick and the dying and the very aged, are the most costly to incarcerate and the least likely to pose a danger to the public.
I don't know if you have the data off the top of your head, but could you paint a numerical picture for us? Like, how many people are we talking about here? It always shocks me to say this, but I hear that in prison, because we age differently in prison, that the age of being considered elderly is 55. Some people say 50, but others say 55. So do you have a sense of what the prison population is that is elderly as defined by over 55? I know if anyone else is listening who's my age, you may be shocked to hear this, but that's the age. So do you have a sense of how many people are impacted or are aged in prison to that extent?
I don't have a current number. It is said that by 2030, our state prisons will house 400,000 people who are aged 55 and older. They cost anywhere from 3 to 10 times the cost of their younger cohorts to incarcerate. Medical care is consuming an increasingly large percentage of prison budgets. So Part of this is due to those mandatory minimums I was talking about earlier. Our prisons are graying due to tough on crime policies that both inserted these mandatory minimums, but also eliminated second look mechanisms like parole. Many jurisdictions no longer recognize parole. So there's really no way to go out and capture these individuals and get them out. And then we have prisons that face significant challenges supporting elders who are living, they don't have age appropriate supports like mobility aids, lower bunks, hospital beds. They don't have memory care, other kinds of supports that we take for granted in the outside world. And 55 is not the standard in prisons for geriatric release. It can be 65, even as old as 70.
Big range, right? I mean, some states have 50, some states go all the way, as you just said, up to 70. We'll get into some of this wonkiness between states because it is so varied. But just staying with this idea of compassionate release. So some of it has to do with people who are really ill, right? And when we think about medical parole, it's a form of compassionate release. Why don't you tell me, how do they define medical release? Who's typically qualified? How does it work?
Unfortunately, there's no typical anything. I mean, we're looking at 51 jurisdictions, well, 52 jurisdictions with the District of Columbia, 50 states, the District of Columbia, and the federal system. And there's very little continuity among them. What defines serious medical illness can be anywhere from you can't get out of bed at all, you're completely incapacitated, all the way up to a person whose condition limits them in one or more what we call activities of daily living. They're unable on their own to walk or on their own to bathe themselves or feed themselves. And everywhere in between. Terminal illness, we treat as a different category, although obviously it's due to a serious illness, but many programs define terminal conditions as worthy of compassionate release consideration. People who have those. And again, there's no continuity. It ranges anywhere from a person who has a condition that has an end-of-life trajectory, that's like the state of California, all the way down to a person who is not qualified until they're within 30 days of death. And that's the state of Kansas, I believe. And so then you have everywhere in between. They tend to fall in the 6-month to 12-month prognoses. But again, there's no standard definition across the country. On our website, we have a chart, compassionate release state by state, and you can see all the different criteria. And then for every single state, whether it's 6 months or 12 months, whether it's 70 years plus a terminal illness or 55 years with an age-related condition, all of those are sort of laid out in a kind of a simple way to get the complexity and the variety that we see in the federal, or rather in the state systems particularly.
Yeah, I can't remember what jurisdiction it was in, but I remember reading a case of a man who was literally a quadriplegic and, who's quite ill on top of that. And he somehow managed to submit an application or be considered for compassionate release. And he was denied release because they said he could still speak and therefore he could order somebody to do something. And I was just flabbergasted. I was struck by the cruelty of that. It just seems so incredibly cruel, particularly given what we know about prisons and medical care, which is that they don't do such a good job. In fact, they do a bad job. And so that's medical parole, right? We know that, I guess. And of course, I'm sorry, just to add one other thought, is this idea of imminent death. I mean, most doctors won't tell you if you're imminently dying. That's sort of not what they're trained to do. And who can predict that properly anyway? So that's really tricky, right?
It is. When we're working with lawmakers or policymakers, we're moved to suggest to them that they not rely to find a terminal illness by some number of months or years from death. As you said, medical professionals are really loath to. It's not a science, it's maybe an art, but they're very loath to tell somebody, yes, you're going to die in 6 months. I mean, it is something that they'd rather not do. And they typically, we understand from medical professionals who work in this field, typically will give people a longer prognosis of time left to live just because they don't want to deliver bad news. And it's just human. I mean, it's kind, but unfortunately, in this context, it's a problem. One of the other things I think that medical professionals come up against is this idea that some of them are expected to also weigh in on whether or not the individual, whether they're dying or seriously ill, will continue to pose a risk to public safety. And as you can imagine, medical professionals don't want to do that. It's not in their skill set, number one, and they can't do that. But number two, they're conflicted by their own oath. I mean, they're there to serve the individual, to help them, to get them back to health or help them out of life kindly, not to weigh in on whether or not they should not be released because they might still be able to pick up a phone and order a hit or whatever crazy ideas.
It's just an absurdity, really. And you mentioned geriatric release, this idea of releasing the very elderly. Is that a separate and apart concept? So if I'm 85, I'm making up a number, if I'm over 70 in these states, can I simply apply on the basis of age alone? Or does it always have to be age combined or concurrent with some kind of severe medical condition?
For the most part, it has to be in combination with something. So in the federal system, it's age plus time served. In state systems, it can be anywhere from age and a terminal condition to age and a chronic medical condition that's not, that's age related and isn't going to improve. And in some cases, age and whether or not you've served enough of your sentence.
Yeah, I mean, that's one thing that, when we think about this health trajectory of people who are incarcerated, many people who commit a crime come from sorts of backgrounds that are already so disadvantaged to begin with. And so, to your point, they don't enter prison particularly healthy relative to perhaps other populations. And then prison just exacerbates that. Now, you sort of keep toggling between these, and I know it's a complex subject to talk about, but you keep talking about the federal system versus the state system. And I do know they're quite different. So you wrote a terrific report, right? I mean, a terrific report. I think it's the gold standard for compassionate release in the States. It's from 2018. It's called Everywhere and Nowhere, Compassionate Release in the States. And I love that because what you're essentially reminding us is that every state, I think every state has some form of compassionate release, and yet it's used so infrequently, so stunningly infrequently. So I'm wondering if you could just sort of tell us some of the things that you know about compassionate release in the states. I don't expect you to do a 50-state survey, but maybe take a state or two that you know is of particular interest to you, or maybe tell us a story or two about how compassionate release plays out in practice.
I'll just give you a little bit of background. We wrote the report because, as I said, we've been hearing from individuals over the years who were in need of help with compassionate release. And I'd done a lot of work on the federal side, but we realized that we were getting a lot of calls and interest from people in states, and we really knew nothing about that. So the first thing I do when I have to learn something more is learn something more before I can answer a question. And so we really dug in to examine compassionate release program in every single state. And what we were struck by, and why we named the report Everywhere and Nowhere, was precisely as you identified, that nearly every state, with the exception of Iowa, has some form of compassionate release, but it is seldom used. And so we went in to look at what were some of the barriers to compassionate release. What were the problems? So we unpacked all these programs, and then we began to look at what were some of the problems. And a lot of them shared sort of categories of problems. So, for example, eligibility criteria. I was mentioning earlier about Kansas and its 30-day requirement for terminal illness. That's going to absolutely pose a barrier to anybody who's terminally ill. I mean, even if you get to the point where a doctor will say somebody's within 30 days, you don't have enough time to get through the system. You don't have 30 days to go through an entire process. Other barriers included strict categorical exclusions. There are states that will not allow people to even apply for compassionate release if they've been convicted of certain offenses or if they have a certain kind of a sentence. So if they're sentenced to life without parole, or they're sentenced to death, they are not eligible for compassionate release.
There's a real irony there, right? I mean, because those are the folks who are the people serving life without parole or life sentences. Those are the ones who are graying in prison and getting these age-related conditions.
Exactly. There are a number of systems that don't recognize geriatric parole or geriatric release at all, which is another. So you have to sort of shoehorn people into other systems. There are states like the state of Maryland that have statutes that provide for compassionate release and regulations that don't align with the statutes. They have two different sets of criteria. And so there are programs that are absolutely unmanageable like that. There are states that go back, even though a person is certainly eligible for compassionate release, the system will go back and look at what was the crime that they committed? How serious was that crime? Would releasing an individual early undermine or send a message about our commitment to victims or our commitment to holding people to justice? Maryland has been a particularly bad state for that as well. And actually, you'd asked about stories. I was writing a report behind the state parole report card project that you talked about. And we highlighted a story of an individual named Donald Brown, who I knew about, who had been seeking compassionate release in Maryland. And we were not involved in this case at all, but he was very advanced in years. He was dying. He had a variety of conditions, complex type 2 diabetes. He had his leg amputated. He suffered from congestive heart failure, and he had dementia, which had been caused by a stroke, right? And he was unable to remember where he was. So he was incarcerated, right, in a state prison, but sometimes he thought he was in the halfway house. And other times he was pretty sure he was in Virginia, but he wasn't, of course, in any of those places. He was a Maryland state prisoner. And by the time he asked for or sought, I'm not sure if he did it himself or somebody else did, he was confined to a bed or a wheelchair night and day. He had to have help with basic things, dressing, moving from place to place, eating, toileting, everything, bathing. And if you or any of your listeners have lived with or experienced somebody who's had cognitive decline due to age or otherwise, they have to be constantly cued. But he was denied compassionate release by the Maryland Parole Board because they considered him a bad candidate due to his offensive conviction. Now, fortunately, he had a lawyer, which is really rare, but in Maryland, Maryland's one of the states that does allow lawyers to represent or support individuals seeking medical parole, as it was called in Maryland. And he was ultimately granted release in mid-June of 2020. But because the Department of Corrections had just not prepared a release plan for him, he didn't get released right away. And in fact, it was more than 2 weeks later when he was released. He had to be released to a hospital, and he died within 4 days in the hospital. That story is like so many others we've heard of people who received poor or bad medical care, who were expected to advocate for themselves to get out in the first place. I mean, many of these programs don't permit outsiders to ask for help with compassionate release. And so these individuals are expected to navigate on their own. And it is heartbreaking.
Yeah. And I mean, really, when you think about the function of a prison, I think to the layperson, it's to punish. And when you're talking about somebody, and I'm not saying that's correct or that I agree with it, but, I think that's the general idea. And when you think about someone who has full-blown dementia, who can't take care of themselves and doesn't even know where they are or why they're there, the idea of punishment kind of just goes out the window.
Right. Much less rehabilitation or deterrence, right? I mean, what we were talking about earlier was this idea that we have to take a second look when continued incarceration fails to continue to meet the purposes of punishment. And if you've got somebody locked up and we're paying a lot of money for him to be in a medical unit, probably, we're paying for somebody who will never benefit from rehabilitation, who's going to end his life very soon, who doesn't even know where he is, who's not cognitively available for punishment even, probably doesn't even know he's being punished any longer, right? He's in Virginia or he's in a halfway house. It boggles the mind how we cannot get to that point. Second chances, as I said, should be reserved for people who shouldn't be locked up any longer. But when you think about the most worthy cases, people at the end of their lives, people who are suffering from debilitating or incapacitating conditions, there's simply no reason to keep them there. We hear opposition, particularly from prosecutors, that victims were told these people are going to get locked up for this period of time, that we're going to be incarcerated for the rest of their lives, and we need to keep faith with them. But I think that monolithic use of victims is probably inappropriate. And I know that in certain cases, survivors and victims have said, yeah, let this individual go.
Yeah, for sure. And you mentioned medical facilities. Some prisons actually have had to develop geriatric wings, right? I mean, hospice care wings or dementia wings, right?
Exactly. Yes, they have. I mean, because they've got to be able to manage this population. I mean, particularly people, I think, with cognitive damage or conditions, they might think they can just walk out the door. People who can no longer process speech and don't know how to follow directions get punished, and they get put into specialized housing units or the hole even because they're not obeying commands, and there's no give in the system, right? You have to put them into a new setting if you can.
So, Mary, you were just referencing the whole solitary confinement idea. So imagine someone who's unable to follow directions, actually, who's not following those directions because they don't understand them, and then being punished and put into solitary confinement, alone and confused and experiencing all of those things. I mean, torture. And it's the antithesis of what we should be doing with people and to people. There's some of the stuff that happens at the state, some of the exclusions, some of the challenges. And you talked about this very Byzantine, difficult, opaque process to apply for compassionate release. How long does it typically take for a person who's incarcerated in a state facility to even have their applications for compassionate release considered?
Some states have very, very lengthy and complicated review processes. So you'll begin an application at the Department of Corrections level, at the facility level, and it'll get reviewed by a medical person, obviously, maybe more than one. It'll have to go through a medical review higher up. Meanwhile, there's an institutional review. Does this person even qualify for compassionate release, or are they excluded because of the nature of their conviction or the length of their sentence? What has their disciplinary been like? And they have to put together a lot of information and assessments. And sometimes those things can take quite a long time. The best programs have deadlines. You have to complete this assessment by this time. You have to get this person before a judge within 10 days of medical is in California, having said that this person qualifies. But there are other systems that it just breaks down because of all the layers of bureaucracy, all the layers of review, or simply it gets stuck on somebody's desk because they don't know what to do. They don't understand what they're supposed to do. The rules are not clear. And I'm not blaming those staff people at all. They're actors in the system, but they may be dealing with criteria or guidance that's so unclear or so contradictory that they don't know how to act. And so things will get stuck on the desk, and it's paperwork, so much paperwork in the system, it will just pile up. And again, these are human beings. Many, many prisons are now understaffed. So I'm very aware of that problem. But what it means is that we have requirements written into the law or written into policy that will slow the process down. And without deadlines, without clear guidance to actors, this can delay people's for months and months. And we knew of people in the federal system who died waiting for an answer from the warden. That shouldn't have happened. That person should have been identified and forwarded very quickly. So this happens in the state systems as well. People die while waiting for an answer.
If you had to, I mean, I know you have this report card. Is there any state that does compassionate release well? Or what state is the worst? Who gets an F?
I think Maryland got an F or close to an F. I'm a little embarrassed to say we gave A's to some states that probably didn't deserve them. Full disclosure, we were working with publicly available materials. So we looked at statutes and regulations and rules, and we FOIA'd how they were doing. And no, Colorado got pretty good grade for clarity. Criteria were easy to understand, which is super important. Eligibility criteria, understanding what it is critical for the process of identifying people, sort of all the way through. But we published a report and we got calls from people in Colorado saying, no, it's not working. And I realized that there's and we had been very clear that we were only working with publicly available information. But, it's quite one thing to look good on paper. It's quite another thing to be good in practice. And, we'll talk about the federal system later, but it motivated our initiation of the Compassionate Release Clearinghouse at the federal level, because a great reform passed to compassionate release. But we realized if we didn't do something to make sure that it was going to work, then it might very well fall on its face. So I really want to go back and look at those states, Illinois, District of Columbia, Colorado, a couple of other ones that got really good grades, and find out, wait a minute, were we right? So it's just a little preview for your listeners that there'll be more about the report cards. We're going back and redoing right now, going back and updating all of our state memos. So we'll have more report card material, hopefully following on that.
Yeah. And I mean, the truth is you're working, as you said, with public information. A lot of the departments of corrections at the state level do not track and certainly do not share compassionate release data. So that makes it super hard to see what's working.
On the flip side, California, which had gotten not a great grade in the last 2 years really, really revamped their compassionate release program, and it's working really well. So we're updating that information. One of the things that's really working there is that the medical directors at the prisons, once they've made a determination that the individual meets the compassionate release criteria, that then triggers the notice to the courts, and the process then begins in the court system. And there's a presumption of release, which is
Yeah, it's a big deal.
revolutionary. Yeah. Yeah. So if a person is found to meet the criteria, the court has to overcome a presumption that the individual, with a finding that the individual would pose, I think it's a threat to a specific other person. I'd have to go back and look, but there's no other program that does that. And I think it's really the gold standard.
Okay, I mean, that does sound good. And you just mentioned before that there was also a change in law at the federal level. So can you tell us about how compassionate release works or doesn't work at the federal level?
Sure. Yeah. In the federal system for many years, starting with the Sentencing Reform Act in the late 1980s, the federal system sort of eliminated parole. It cut the amount of good time that people could have. And it basically removed any discretion for the judge to revisit a sentence once it had been imposed. But also in the Sentencing Reform Act was a compassionate release provision providing for the early release of individuals if they met certain criteria. And the statute provided that the Sentencing Commission would create the criteria for compassionate release, or release from prison for extraordinary compelling reasons. There's a long name. The Bureau of Prisons would be the agency that was responsible for identifying people who met compassionate release criteria that the Sentencing Commission outlined and bringing those cases to the attention of the sentencing court with a motion for compassionate release. And then the sentencing court was given the job of whether or not it agreed that the person met compassionate release criteria, but then making the additional finding that the person deserved to go home. And they would use the sentencing factors that are typically used as sentencing, called the 3553A factors. So sort of a review of history and circumstances of the offense, history of the individual, rehabilitation, a variety of sort of factors. And so on paper, the program looked really good, but the problem was that it was really badly flawed from the beginning. And the Sentencing Commission took over 20 years to write any kind of criteria. So there was no criteria out there. So the Bureau of Prisons, because it had to, wrote its own criteria. But it also wrote things into its criteria that had to do with the substantive consideration of whether or not a person deserved to go home. So in their criteria, they included considerations about whether the person has spent enough time in prison, whether their crime was heinous, or if releasing them early would undermine the seriousness of the offense. And so they routinely would find that individuals were within 6 months of death, but did not deserve to be released because in their view, they posed a security threat or hadn't spent enough time and so forth. And the problem with that was it was only the Bureau of Prisons that could file a motion to the federal court, right? And so what happened was that lots and lots of people were denied compassionate release because the Bureau of Prisons had taken on the court's function of defining whether or not a person would be released. And so the third reason that the whole system was broken was because there was no appeal of this. It's not like a federal agency that makes a decision like Social Security Administration and then you get to go to another body. No really meant no at the end of the day. So when we figured this out a while back, we and others began to really push on the Bureau of Prisons, on the Sentencing Commission, on Congress to do something about this. And ultimately, the Sentencing Commission came up with criteria and then they improved on them somewhat, like in 2016, and expanded the criteria. And one of the things they did in 2016 was to say, look, here are the criteria, and the Bureau of Prisons basically needs to bring these cases to federal court and let the judge decide, because the judge is in the best situation to figure out whether or not an individual deserves to go home. And the Bureau of Prisons didn't do that. And every year, only a handful of people got out under Bureau of Prisons' watch. And so some lawmakers began to ask questions and found out that the Bureau of Prisons was not following the guidance from the Sentencing Commission. They got fed up and they wrote a statute that said that not only the Bureau of Prisons, but also individuals themselves who are incarcerated can file motions in court. And that statute got folded into the First Step Act that was passed at the end of 2018. And we all thought it was going to get thrown out, in negotiations, but nobody seemed to notice it, right? And so after we finished celebrating, as I mentioned before, we realized that judges had never seen a compassionate release motion. Only 25 a year were made it to the courts. And that we had access, because we were in constant contact with prisoners through a phony email system called Core Links. We're in contact with lots and lots of people. So we decided to set up a compassionate release clearinghouse to test the system, to see if this was really going to work. And so we asked people to tell us if they met the criteria. We reviewed their cases, and then we began to recruit and train and support pro bono lawyers to represent those individuals. In the first year, compassionate release motions more than doubled. And then during COVID, which struck right after that, so in March of 2020, we realized that it might be possible for people who were in danger of serious illness or death because of an underlying condition from COVID might fit the serious medical conditions prong that the Sentencing Commission established. And so we just kicked the walls down of our little bespoke project. And I think we heard from 5,500 people who answered our request for information. We placed a lot with lawyers all around the country. People were doing this. It wasn't just FAMM. Federal defenders were doing a lot of this work. And during the COVID years, over 4,500 people were granted compassionate release. 1% of those granted motions were from the Bureau of Prisons. So that law, the compassionate release law that got folded into the First Step Act, was a lifesaver for a lot of people.
Amazing. And obviously at the state level, various states had different decarceration programs to protect the most vulnerable people in prison. But yeah, at the federal level, that was really impactful. So what's been happening now? What are you seeing on the ground?
There's so much that's going on, particularly in the federal system. So there was a period of time after 2018 when there was no sentencing commission to make new rules for compassionate release. So remember, the statute had said two entities can basically bring a motion. One is the Bureau of Prisons, and the other is the individual themselves can file a motion. But the sentencing guideline, the Sentencing Commission's policy statement governing compassionate release, did not recognize that. It hadn't been updated, right, to recognize that incarcerated people could file their motions. It's still limited. And judges had to follow the sentencing guideline rule, not necessarily the statute. And so a number of courts basically ruled that in this period when there was no amendment or update to the sentencing guideline that governs compassionate release and its criteria, that basically judges did not have to follow the sentencing guideline because it wasn't applicable. That's why we got, I think, so many people out on COVID, because the COVID vulnerability didn't quite meet compassionate release criteria, although eventually the Department of Justice began to sort of recognize that they could kind of shoehorn COVID vulnerability. But while all of this is going on, other really smart lawyers and litigators are thinking about, well, wait a minute, what else is a so-called, in the statute, it's called not compassionate release, but release for extraordinary and compelling reasons. So there's some other extraordinary and compelling reasons out there, right, that are not recognized by anybody right now. And sort of one of the most important ones was that there were people who are incarcerated who are serving sentences that can no longer be imposed today. One of the things the First Step Act did was to dramatically lower some very, very severe mandatory minimums for drug and gun offenses. So they made that change prospectively, but they didn't make it retroactive. And so all these people are serving life sentences and 25-year sentences, and sentences that are longer than lifetimes for gun offenses, for example, were set to sort of continue to serve those sentences, even though Congress had repudiated them and had shortened them.
Just so folks are following, when Mary talks about prospective versus retroactive, it means when a law is passed, prospectively, it applies to anyone new who's charged, but it may not apply to the people who were already serving sentences under an old law, even though there's been this change of law. And had they committed that same crime today, they wouldn't have landed in prison for anywhere near the length of time they were serving.
And so these inspired litigators began bringing these cases, and courts began ruling on them. And it was extraordinary because there were a number of courts who agreed, yes, this person brings me an extraordinary and compelling reason. They are sentenced to 145 years because of stacked gun offenses, and today they'd get 30 years. I'm going to reduce their sentence to 30 years, or even time served sometimes. And this happened all over the country. And of course, those cases began to be opposed by the Department of Justice. And as they percolated up through the courts, there were circuits that agreed and allowed those cases to go forward and others that stopped it. They said, well, had Congress wanted those changes in the law to be retroactive, they'd have said so. And new sentencing commission can't just tell the Congress what to do. So that's sort of the state of the law when the commission came back. And because the statute requires an applicable policy statement, the Sentencing Commission decided to expand compassionate release. And one of the things that expanded compassionate release to include were so-called unusually long sentences. And that meant people who were serving sentences that could no longer be imposed. They'd served at least 10 years of the sentence. And there were several other criteria, but basically they recognized that as a ground for compassionate release. And it was because of this litigation that had gone on that had really raised the issue, and also advocacy from groups like FAMM and others, that excessive sentences ought to be recognized as a ground for compassionate release. They also changed compassionate release criteria to include inadequate medical care in the prisons. So if somebody's not receiving medical care and they're threatened with death or serious advanced illnesses, they can get out for compassionate release. They recognize caretaker not just for children who are left without a parent, but for adult children who cannot manage on their own without a parent or somebody caring for them, and also care for aging parents who don't have anybody else to watch out for them. So there were lots of expansions of compassionate release criteria in this last period that have been just super gratifying to see.
And are you seeing that people are getting out? Because there's a difference, right, between being eligible for release under a compassionate release statute and actually being released. So are people who are eligible actually being released from prison?
A lot of them are, but remember that the courts have two things to look at. One is whether one is technically eligible, and the other is whether they deserve to go home in light of these so-called 3553A sentencing factors. So does their release compromise public safety? Is their release warranted in light of the severity of their crime and the need to meet the purposes of punishment? Would releasing them early create an unwarranted disparity between them and people similarly situated?
So let me ask you a question. Can you give us an example of a story of someone who maybe benefited or maybe who didn't benefit at the federal level from compassionate release?
So Michael Mahoney was living in Texas and dealing drugs on the street. And he was arrested and convicted of 3 state felonies for hand-to-hand drug sales to an informant. I think he served a little bit of time in state prison, maybe not. But when he was released, he went home to Tennessee. He was done with dealing drugs. He started a pool hall. He employed people and he paid taxes and he was conscientious, and he had to take this is a long time ago, so he had to take his night deposits, right? The cash he earned every day to every night. And it was not a great neighborhood. And he realized that he probably needed some protection. So he went to the local pawn shop to buy a gun to protect himself. And the pawn shop owner gave him an ATF form you have to fill out. So he fills out this form. And one of the questions on the form is, have you ever been convicted of a felony? And he said, geez, I have. And the pawn shop owner said, don't worry about that. It was more than 10 years ago. And Michael had been able to get a liquor license, right? Even though he had a conviction, but it was stale at that point.